All right, now let me read my little spiel. Good morning. Thank you for joining us for this week's Weekly Wednesday presentation from the Legal Aid Society of Mid-New York. This presentation is being recorded and will be uploaded to the Otsego County Office for the Aging Facebook page and to our county website. I ask that everyone except the presenter and myself keep your videos turned off and that you remain muted unless you have a question. Please feel free to unmute yourself and ask questions as we move through the presentation. You can also use the chat feature if you prefer, and I will ask those questions for you. For those who are new to weekly Wednesday presentations, we host presentations every Wednesday using the same link at 11 a.m. Topics are on various community-based services and organizations and topics relevant to long-term services and supports. We established this in October of 2020 as a way to continue education on services and supports amid a global pandemic. For those who do not know me, my name is Alicia Chase. I'm Otsego County's long-term care coordinator. My role here at Office for the Aging is to supervise the New York Connects program, which provides information and assistance on all long-term services and supports available in the county. Although my office is under Office for the Aging, we are unique in that we are able to help anyone of any age who is looking for help navigating this complicated long-term care system. We can assist people who just want information and assistance, are looking for referrals to other community-based organizations. For example, the Department of Social Services, Mental Health, SPOA, the Catskill Center for Independence, Family Resource Network, just to name a few. We can also assist people who need help with applications and those who need assistance navigating placement for their loved one in an adult home or a nursing home. If you are unsure if New York Connects can help you or your loved one, please do not hesitate to reach out. We also have a New York Connects partner, Vince Baker, with the Independent Living Center in Oneonta. Those wishing to reach out to me can do so by calling Office for the Aging at 607-547-4232. At this time, I'm going to turn the program over to Alice Decker with the Legal Aid Society for today's presentation.
Thank you, Alicia. I am momentarily going to share my presentation by popping it up on screen here. If you can't see it for some reason, please let me know. As Alicia said, my name is Alice Decker. I'm a managing attorney of the Legal Aid Society of Mid-New York. I work primarily out of the Oneonta office. However, I supervise also the Cooperstown office that we have, and also certain programs that cover our entire 13 county region here in central New York. Currently, I'm working predominantly on a grant that's provided through the Office of Victim Services in New York State, providing services to victims of domestic violence, but I have in my past life done a fair amount of elder work through our various contracts with the Offices for the Aging and in our various counties that have those contracts. Currently, we do have contracts to do that work in Broome, Delaware, Otsego, and Shenango counties, and those are all administered out of our Binghamton office, which I kind of supervise with the Binghamton office manager, who is Lauren Prasky. So today we're going to be talking about about wills, and in the context of a slightly broader subject matter of estates. And so I'm going to go ahead and put this up, and hopefully everyone will be able to see it. So as the opening slide says, this really is a basic presentation about wills and estates. There are many, many complicated issues around the issue of decedents' estates and wills. And if you have some of those issues, or you're working with folks who have complicated issues, legal aid might not be the referral agency for those folks, but we do encourage referrals to be made. And in Otsego County, we do require a referral from the Otsego Office for the Aging in order to access our services for elders. Now, anyone can contact legal aid if they have a civil legal issue, but unless the case comes through Otsego OFA, we do have eligibility guidelines, financial eligibility guidelines that must be met if someone comes through in a different way. Otsego OFA can refer people to us if they are 60 years or older with, as I said, a civil legal issue. And that can include wills and the subject of our last presentation from last month, which was powers of attorney and healthcare proxies. So we'll go ahead and get started. As always, I start with vocabulary. It's very hard for lawyers to talk about things without using the vocabulary that we learn, and also because things have very specific meanings. So this is the vocabulary of inheritance. So will is a formal document that disposes of all assets and gives certain other instructions. The will is that of the testator, the person who executes the will, the person who is really contemplating their death and wanting to be prepared, largely so that their family can navigate through the system without, well, or at least with reducing any sort of conflict or strife. A devisee is a person who receives a gift in a will. Executor, excuse me, or sometimes it's called executrix if it's a woman, is a person that the testator names to carry out the wishes in the will. A bequest is a gift made in a will. I will sometimes say bequest, sometimes I will say gift. They mean the same thing. Intestacy. This is the law that decides what will happen to the property of a person who dies without a will. And so when we're talking about estates here, that's the sort of large overarching construct. The estate, the decedent's estate, is everything that the decedent owns or owed at the time of their death. And as it says here, if that person died without a will, then we have to look to the law of intestacy, and we're going to talk about that a bit more down after we get through the vocabulary section. An heir, unlike a devisee, an heir is a person who will take the decedent's property if there is no will. And then I want to focus on this word issue. This is the decedent's children, grandchildren, etc. These are the lineal descendants of the testator. And it goes down as far as there has been children, grandchildren, great-grandchildren, great-great-grandchildren at the time of the decedent's death. If the decedent testator wants to limit that, then they need to limit it to a class of individuals. So for instance, if you don't want your property to pass any further than to your children, you need to say children and not issue. Otherwise, that's going to cause some interesting issues. So that is vocabulary. We're going to look at intestacy first. Sometimes when clients come to us, the question that they have, or maybe the question they don't even know that they have, is, do I need a will? And so our process is designed to elicit from the client, what is it that you want to have happen when you die with your property? Just tell me what your family is like, tell me what you have. And we use an interview process, a questionnaire process to elicit all of this information from the client to figure out, does this person even really need a will? Because sometimes the person comes in, they're married, they have a couple of children, and what they say, because oftentimes we're doing wills for couples, is, well, I want my spouse to take everything should I die, and then if that person were to predecease me, I want it all to go to my children in equal shares. That's exactly what the law will do if the person dies without a will. So the advice given is, at this moment in time, as you sit here in front of me, based on what you have just told me, you don't need a will. Now, sometimes people want to plan for further out, or they want to deviate. So let's talk about what intestacy is. The law that sets forth the rules of how that person's property will be disposed. The catch on this is there can be no deviations from the law of intestacy, and no weight will be given to what the decedent may have said during life about what he or she wanted to happen. This is not something that the court can say, yes, John, I understand that your mother died, and before she died, she said, I want you to have it all, John. And maybe that was even sincere. But if there is no will, the law of intestacy rules, and that must be strictly followed. And there's nothing that the probate judge, who in New York works in the surrogates court, can do about that. So what does intestacy say specifically? If the decedent's estate is worth $50,000 or less, and he or she left a surviving spouse, the entire estate goes to the spouse. If the decedent's estate is worth more than $50,000, and he or she left a surviving spouse and children, the first $50,000 goes to the spouse, and then the remainder is divided half to the spouse and half amongst the children. If the decedent left no surviving spouse, but did leave children, the children will divide the estate equally. If the decedent left no spouse or children, the law will look to first the decedent's parents, then to their siblings, and then to other relatives. If the decedent left no intestate relatives, which frankly almost never happens in New York because it goes out pretty far in terms of cousins, their estate will escheat to the state. So what does that mean? If a person dies without a will and leaves no relatives that the law says that can receive property, they're an heir, and that they can receive property under the intestacy law, the state of New York gets everything. Most people do not want that to be the outcome. So most people, once they've had that conversation with us, and every once in a while we have someone who comes in and we talk to them and it really turns out they have no relatives, then we counsel them about, what they can do with a will. So that brings us next to the issue of wills. First, and I'm going to talk about it second, but I'm going to say it first, is that a will must meet all the legal requirements to be valid. And we're going to discuss what that means below. But since we were talking about how the state would be divided when there was no will, let's continue that conversation about how the estate will be divided if there is a will. So the property will be divided as it's set forth in the will, with one really important exception. If the testator is trying to disinherit their spouse by writing a will that writes the spouse out of the will, then the spouse has what's called an elective share to the will. So they can elect against the will. Now, that sounds voluntary, and it absolutely is. The spouse can say, look, I know that my husband or my wife left everything to the children and left nothing to me, but that's fine. That's exactly what he or she wanted to have happen, and and I'm going to honor that, or that's what we planned for, whatever it may be. So, but the spouse can elect against the will, which means that the spouse, if he or she chooses, can demand that the court grant him or her the greater of $50,000 or 1/3 of the net estate. There are some things in the estate that are actually in the decedent's estate, but then are removed from the decedent's estate. We're going to talk a little bit about that. So that's why it's net. It's not necessarily the whole of it. And it is the greater amount of those two things. So if we had an estate of $1 million and the spouse was left out of the will and is electing against the will, clearly, I'm not great with math, as you're going to see later on, but clearly 1/3 of the net estate of $1 million estate is probably going to be more than $50,000. So it's the greater of those two numbers. So we now have this document, this will, that sets out all of this. And our clients frequently ask us questions about what would happen if all of the devisees, and remember those are the people who will take gifts or requests under the will, if all of those people who are named in the will predecease the testator, what happens? That means that the estate then will be disposed of according to intestacy. So if the testator went to all the trouble to write a will and make sure it was valid and all those sorts of things, but then by the time they passed away, none of the folks to whom they left things were survived them, then the law will look at their estate as if the will had never been written, because there's no person to disburse the property to. Here's what I was talking about before, where there is some property that can pass outside the will, meaning not go through the probate process. One very common example of this is real property. Real property is everything that's everything that is encompassed in land and houses. So it can be a house on, a building lot. It could be a camp up north. It could be just a vacant lot somewhere. So that's real property. If it is part of a tenancy by the entirety, this is a very specific kind of deed that is only applicable and available to people who are spouses. The other kind of deed might be a deed for a joint tenancy with rights of survivorship. And this basically says, here are these folks who have bought this piece of property or maybe inherited this piece of property. Each person holds an equal interest in the property. And as each one of them passes away, if the property is not sold before they die, as each of them passes away, the remaining tenants sort of absorb that person's share in the property. And so theoretically anyway, at the end of all of this, you'd have one sole owner. This sometimes happens when children inherit from their parents the house, or maybe the house that their parents lived in, or perhaps a vacation property or something like that. And it's left to all the children equally as joint tenants with rights of survivorship. And it's very important to note that that deed needs to include language like that. Otherwise, a whole different kind of ownership is created. And the situation that I just described does not happen. Life insurance proceeds will be paid out to the named beneficiary. Now, a life insurance owner, the person who's insured usually, can dictate that the life insurance proceeds go into their estate upon death, but usually that's not what people want. Usually people want those proceeds to be paid out to a named beneficiary or beneficiaries, a lot of times to pay for funeral expenses and other things. And so if you route that through the estate, first of all, it gets all tied up and you can't use the money for those purposes. And second of all, it then becomes subject to whatever is in the will. Some personal property, and personal property is just everything that's not land and houses, such as joint survivor bank accounts or properties placed into an inter vivos trust, will pass outside the will. Inter vivos is a word that we use in law a lot. It just means during life. So if someone creates a trust document during their life, the instructions of that trust are going to be followed. A person can also create a trust within a will. That's called a testimonial trust. That is an example of a complicated issue, that's something that legal aid would not do. And if people believe that they have, first of all, reason to, and second of all, sufficient assets to establish either an inter vivos or a testamentary trust, that's something that really needs to be done through an estate planning law firm, because it doesn't meet the qualifications of simple wills, which is what we do. All right, so now we're going to get into when is a will valid? The first thing to understand is that each state has its own rules and people move around a lot. So it's not at all uncommon that someone who dies in the state of New York may very well have had a will that was drafted in a different state. That state may have, and probably does, have different rules than New York State has as to creating a valid will. But simply because a will was created in another state doesn't mean that it can't be probated here. So it's a good idea, if you are coming in from another state and you have a will, to talk with a New York State lawyer about whether or not you need to change that for whatever reason. But it's, if you just don't get around to it or whatever, it doesn't mean that, all bets are off and then we're dealing with the law of intestacy. Okay. So let's talk about validity. In New York State, a will must be a written document. It must be signed by the testator in the presence of two witnesses. And those two witnesses cannot take anything in the will. They have to be completely disinterested. This issue comes up, I would say, not infrequently. And I know that's kind of a cop-out way to describe it. But the idea that you will have a problem with the will because somebody didn't follow one of these rules, it's not the rarest thing to happen. So the job of an attorney is to make sure that these processes are followed. So, let's sort of break this down. First of all, a will must be a written document. It cannot be anything that is simply, oral wishes expressed by the decedent at some point during their life. The court will not argue about those things. As we talked about before, the court will simply say, no will, no written will. Okay, so we're dealing with intestacy here. The will itself must be signed by the testator. Signature can sometimes be an issue for older folks because perhaps they have some sort of limitation to mobility, or they have a condition, say like Parkinson's, which makes it very difficult for them to sign. This is not a barrier to folks actually signing their will because it does need to be signed. People might also just be illiterate. I mean, that doesn't happen a ton these days, but it can happen, and people have never learned how to write or sign their names. It is acceptable in this state to make your mark. That is considered an acceptable proper signature. Also, people can have their signature what's called assisted, meaning that another person can literally help the testator to sign their name by maybe giving support to their arm or their hand as they sign the document. Another person may also sign on the testator's behalf. So there are lots and lots of options here to make sure that people who want to make a will, and we're going to get into other complicating issues for folks that may be dealing with issues of dementia or whatnot. But if someone is merely having an issue signing, quote unquote, signing their name, the law has lots of ways to help that person accomplish that end so that they can leave their property to the people that they want it to go to. Note that this signature must take place in the presence of two witnesses. A couple of years ago, I, for some reason, was reading a case about a contest to a will in which it was alleged that the testator, who was in a nursing home at the time, signed their will, but the witnesses, who were both employees of the nursing home, were not present in the room at the time that the will was signed. So it eventually came down to the fact that that requirement had not been met, and therefore the will was thrown out. This is the reason why things need to be so carefully supervised when wills are being signed. Those witnesses cannot take anything in the will, so you can't, leave everything to your son and have your son sign as a witness. The witnesses also sign the will. We also have witnesses sign what's called an attesting affidavit, which usually means that those witnesses don't have to go to court to prove up that they were in fact the people who signed the will, they were there, and all of those formalities were met. Doesn't mean that the attorney who's probating the will may not want to talk to them or whatnot, but it usually saves them that trip to a courthouse. And most attorneys do this for exactly that purpose. But if there's never an attesting affidavit, the will can still be proven and can still be probated, so long as your witnesses are still living. Okay, so we're going to talk then more about validity, but now we're going to focus on the testator, him or herself. And the most important thing here is that the testator must have been competent. We call it having capacity. And that's the mental capacity to sign a will. To be competent, the testator must be of sound mind. I'm sure we've kind of all heard that, you know, being of sound mind and body. We've talked about how the body part, not so much of an issue, but the sound mind part, absolutely an issue. At the time that the will is signed. So it's important to talk a little bit about what does that mean. So soundness of mind can be general. As we go about our daily lives, if we are not dealing with severe mental health issues, or as I said before, dementia, or whatever whatever else you can think of that would make someone sort of not be competent. That's having general capacity. And most of the time, the people that we meet in our lives, unless we do very specialized jobs, generally have that, and it's really not all that questionable. But lawyers do. If you've ever attended a will signing ceremony, and if you haven't, you might want to. They're kind of interesting. Maybe just lawyers think they're interesting. I don't know. The lawyer will, in the presence of the witness, ask the testator a series of questions so that the testator can demonstrate to the witnesses that they are in fact of sound mind. This usually is questions surrounding orientation to time and place. Our questions tend to be, where are you right now? And sometimes, who are you, and introduce yourself to the witnesses. But when we're getting down to the clear capacity issues, where are you? When are you? And then we invariably ask the who's the president of the United States question. And I'm telling you right now, no matter who it is, nobody's ever happy about it. So it's, you would think that at some point there would be swinging one way or the other, but no, nobody's ever happy. Even if someone doesn't have this general capacity, they can sign a will during a period of lucidity. So think about the circumstance when someone receives a diagnosis of some sort of dementia. They've been told by the doctor, this is what's going on. They're at the beginning of right after the diagnosis, people frequently have long periods where, they have absolutely no issues at all. And as the disease or diseases progress, there are definitely periods where people are of sound mind. Someone can sign a will as soon, as they find out about their diagnosis, because now they're saying, oh my, I've sort of put this off all of these years and now I just really need to do it. The fact that they have a diagnosis does not stop them from meeting with an attorney, laying out what they want, and ultimately signing a will. As the disease progresses, there may need to be carefulness of timing. The attorney may need to, say, meet with the person at late morning, because that is, they've taken their medication, they are focused, they're not tired out, whatever it may be that leads for that person to be in their best general frame of mind around that time. It's still the attorney's responsibility to make sure that the person has capacity, even if the family says, yeah, come and see mom around 11 o'clock in the morning. She's like sharp, like as a tack in the late morning. The attorney still has the obligation to make sure that that is true on that particular day. So what does the testator have to demonstrate? As we talked about when we demonstrated to the witnesses, we want to make sure people are oriented as to time and place. But in terms of preparing the will, the testator should be able to identify, and this is at a minimum, their estate. What do they own? And they must be able to identify their heirs. Who are the people who would take if they died without a will? So we ask a lot of questions about, do you have a spouse? Do you have children? Do you have adopted children? Sometimes we have blended families and people walk in thinking, well, my spouse and I are going to do a will, and both spouses want everything to go to the children and stepchildren together. Well, that needs to be very clearly specified, because if Wife says, I want everything to go to children. That means her children, her legal children, not stepchildren, and vice versa for the husband. So they need to be able to express to us that that's what's going on. And then having identified heirs, or people who might not be heirs under that example, who are the devisees? Who do you want your property to go to, regardless of who your heirs are? And that could be family, or it could be someone other than family. If there's a question about competency, it may be a good idea to visually record the will signing. The old saying is picture's worth 1,000 words. Well, video is worth way more words than that. The relatives who may contest a will can argue all day long that mom or dad or grandma or grandpa or whoever was not of sound mind at the time that they signed the will. But if that's been recorded and it can be played for a judge, and the judge is satisfied as to competency at that point, it's all over but as I said to somebody the other day, it's all over but the weeping. So let's talk a little bit about what kinds of gifts the testator can make in a will. There are generally two kinds. The first is a specific bequest, and this is a bequest that identifies a specific item. The example I give here is a testator's boat and a specific devisee. So I, testator, leave my boat to my cousin Mary. That's a specific bequest. When these are placed in the will, they get distributed first. So before anything else happens, all the specific bequests are identified. Items are pretty straightforward. Money can get a little complicated. If someone, for instance, testator leaves, $5,000 to my niece, because she was so good to me in my declining years, and there's not $5,000 cash money in the estate, then we talk about gifts that abate, meaning that they just go away because they don't exist. And we're going to talk about that a little bit more. So, when we have clients who want to leave gifts of money, we have a really clear conversation with them about, are you going to have the money to leave, or do you, or even do you have it at this moment in time? Because obviously a lot of things can happen in the future, and somebody could say, yeah, sure, absolutely, I have $5,000. As a matter of fact, I have $30,000 in a checking account. Well, a lot of things could happen between now and when the testator passes away, which means that that doesn't exist anymore. And if they want to leave something specific to their niece, maybe they need to think about something in addition to cash. It's fine to leave cash, but say, because you might not have that, is there something specific that that you think would be good for your niece, or that your niece particularly admired, or whatever, so that she doesn't sort of get left out. If the devisee, so in the example that I gave, I, testator, leave my boat to, I think I said John, to John. If John predeceases me, it becomes part of what we're going to talk about next, which is the residue of the estate. The residue is everything that's left after the specific bequests are distributed. And the testator can name a single residuary taker, or multiple ones, or what we call a class of takers. So you could say, that the rest, residue, and remainder of my estate is going to go to John, Mary, and Susan. They're not, obviously they're identified well enough so that the executor can figure out who they are. But John, Mary, and Susan are three individuals. Unless it is specified otherwise, they will take the residue and divide it three ways equally. You can also designate a class of people, like children or issue, that we talked about before. And we're going to talk about more in a second. So it's really important for the attorney to have a conversation with a testator about, what is your picture of what's going to happen with everything that's left if you're leaving it to John, Mary, and Susan, or to my children, or to my issue. And that's why having, conversations with attorneys can sometimes take a while because there's a lot to dig down into. Then we're going to talk about some special problems, or maybe it's more appropriate to think of them as questions that we get from clients, or issues that we raise with clients to make sure that they have complete understanding of what will happen with their wills. So if the testator believes there's any possibility that he or she may be predeceased by all of the devisees, and they don't want the remaining heirs to inherit, then they can name a very last residuary taker as a charity. And we do recommend that they do so. Like I said, anything can happen from the time that the testator signs the will forward until they pass away. But most of the time we don't worry about the most common devisees, who are children and grandchildren, all passing away before the testator. It's not just something, I mean, it can happen, but it's not something that we are normally too concerned about. But if there is a concern, for instance, the testator only has one surviving child and that child has, cancer. There's no telling whether that child would predecease the testator or not, but it's a possibility, and maybe a very strong possibility. And the testator says, I want everything to go to my sole surviving child. I don't want anything to go to the grandchildren. They've been terrible. They never show, they never call, they never write, they never visit. I don't want them to get anything. And then if they don't have anyone else that they would designate, a friend or anything like that, then they can designate a charity who would then have the right to the liquidated estate. A lot of times the direction then will be that everything is sold and the proceeds go to the charity. Here we come up with this word inter vivos again. So conveyances during lifetimes. So if an item was sold or given away during the testator's life, it cannot be devised. So somebody puts into their will that they want their, 2018, I don't know what, Ford Escape to go to their son. Testator executes that will and passes away in 2024. They haven't had that escape for a few years because they gave up their driver's license, the car was sold. Their son does not get the car because it doesn't exist, and their son does not get the cash equivalent of the car either. So, sometimes family members may have an expectation of something in a will that does not come to fruition. That's one of those too bad, so sad situations. There's nothing that can be done about it at that point in time. If the conveyance that's going to be made during life is a gift, so let's say that the testator has grandpa's roll top desk, that was something that had been left to the testator. It's a family heirloom, and they put it in the will to go to a specific child or grandchild or whomever. But during their life, they give that item away as a gift to someone else. That's perfectly valid. Simply because you said that something is going to go to a particular person in a will, it doesn't create some kind of a contract or enforceable promise or anything like that. And if that item is given away as a gift, that's perfectly valid. So let's say that they give that desk to, once again, their niece, but it was left in the will to their son. Son cannot then go to niece and say, give it back, it's mine. However, the testator needs, when giving that gift, to be very clear that it is being given as a gift and not as a loan or anything else. And so the rule of gifting is essentially that there has to be an exchange, an actual, transfer from the original owner to the person who's being gifted. And there needs to be clear intent that a gift was being made. And the best way to do this is in quote unquote public. We don't mean public, but we mean with other people around, that the testator says, you know, niece, you've been so helpful to me, and I know you've always admired Grandpa's desk. I'm giving that to you today as a gift. That is yours, and you can come and pick it up at any time, and it's yours. That statement of intention creates that gift. And John, the son, cannot then, when the will is read and probated, cannot say, well, niece, you need to give me back Grandpa's desk. All right, so here is the sort of big complicated part of all of this is gifts to issue. There are two ways to deal with gifts to issue, these people who are the lineal descendants. The testator can either devise the property to each child's family line without regard to generation or with regard to generation. And as I talk about this, I hope that that's going to become clear to you. If the first way is chosen without regard to generation, grandchildren, for instance, may end up with different or no shares depending on how many children each child had and whether their parent or parents predeceased them. Now, usually in my presentations and trainings, this is the part when I start writing on a whiteboard, but we don't have that right now. So I tried to lay these out here. So here's our example. Testator has 3 children. We've met them before, John, Mary, and Susan. John has 1 child, Mary has 4 children, and Susan has 3 children. In the will, the will leaves the gift, the testator left a gift to the issue. So what happens to the grandchildren that survive their parents? If before the testator dies, Mary and John die, and we're not doing anything with regard to generation, then Susan gets 1/3 because we look at the lines. So there are 3 children, we divide by 3. So Susan, being a surviving child, gets 1/3, and her children get nothing, unless she leaves it to them, but that has nothing to do with the will. John's child will get 1/3 because John died, and his share goes down to his child. And Mary's children get 1/12 each because her 1/3 is divided 4 ways, and so that's a 12th. Some people, testators, are perfectly happy with this, and they're like, yep, that's what I want, and I honestly don't care if the grandkids get cranky. This is what I want. Some testators absolutely don't want that. And that's another conversation that the attorney has to have with the testator to figure out what is it that you want. If we now have none of the children survive the testator, the same thing happens. But then we just sort of redo the math, right? So Susan's children get 1/9 each. In that example, Mary's have their 1/12 and John's child has the 1/3. Sometimes when you put it like that, where you don't have any surviving children, the testator kind of changes their opinion a little bit. And they say, no, that's not what I wanted to have happen. So if the testator wants to recognize each generation, the will can be drafted to readdress the issue of shares if all of one generation, so in the example we just had, John, Susan, Mary, they all predeceased the testator. And then each child, because there's 4 for Mary plus 3 for Susan plus 1 for John, so that's 8 kids, grandkids all together. They would then sort of recombine everything if all the children have passed away, and they each receive 1/8 of the estate. It all depends on how the will is worded. I had folks come in a couple of years ago now, and they had a will drafted a few years before that, and I talked with them about what they were looking for. And I said, is this what you told your prior attorney? And they said, yes. And I said, well, that attorney wrote the will exactly the opposite, was in a way where the result would have been the exact opposite. They're very specific language. It's defined under New York state law. You have to use the proper language. And they just kind of looked at me shell-shocked. It was like, it happens sometimes, but it shouldn't. Lawyers need to be very, very careful on these sorts of things, that they are, first of all, ascertaining what it is their client wants and then drafting the will appropriately. As I said before, It's very, very hard to overturn wills. It's more often that a will is going to be overturned because the process, the signing procedure wasn't done properly, rather than the fact that that somebody will be able to say, well, that's not what grandma or grandpa or mom or dad or whatever wanted. It's very hard to get behind that. I want to talk just incredibly briefly about debts because we frequently get questions. What will happen if I die with debts? Do my children or someone else have to pay my debts? A debt is anything, it's usually cash that the testator owes to another, and they have to be satisfied out of the estate before bequests are distributed. And there's frequently language in a will to this effect that says, all of my debts having been satisfied. But even if that language isn't in there, the law of New York requires this. Creditors must be satisfied before devisees receive their bequests. If there are debts that exceed the amount of the estate, so let's say that the estate is worth $10,000, but there are debts of $35,000, that it will make it such that the devisees receive nothing in the first place. I think that's pretty clear. But the thing that concerns people, testators coming to do their wills, is that their devisees, or perhaps even their executor, who's frequently a family member, will be forced to pay those debts out of pocket. That is not required. If there are creditors who are left unsatisfied because there's just not enough in the estate to cover all of them, so be it. That's just the way it is. However, if a child or someone else pledges in a legally enforceable way to pay the debts, and we won't get into what that means because it's kind of a lesson for another day, but that person might be held responsible. So the lesson is, don't do anything. Don't make any oral promises, though those are usually not enforceable, and certainly don't sign anything. And don't make any sort of I feel bad payments. I talked about it anyway. I have to say on issues where we have clients who have concerns, this one is a frequent concern, and there's a lot of relief for folks when they find out that their children aren't going to be held responsible for their debts. Debts and spouses is a slightly different issue because a lot of times spouses own things and they're both liable on the debts. Again, that's a different issue. And that kind of gets into debtor creditor law in a way that we won't sort of wander into right now. Only one more thing I want to say. This is miscellaneous, but it's also a question that people have for us pretty frequently. I have not spent any time here talking or addressing the issue of estate tax, mostly because this is not an issue that our clients, who tend to be less, who tend to not be rich people, so it's not really an issue that comes up with them. And on the infrequent times that it could come up, again, it does not lend itself to simple will drafting, advice and counsel, and those sorts of things. And then we make the general recommendation to our clients that they really need to spend a little bit of money and go and see an estate's attorney who will usually also be practicing and be able to give them a complex estate plan that'll address things like dealing with estate taxes. The one thing I will say is that even if some property doesn't pass through the will, it can be part of the taxable estate. So, don't think to yourself, oh, she said that everything that's in here or there or whatever, that's not part of the estate. Not part of the decedent's estate, but it might be part of the taxable estate. It's really important to see a lawyer who practices in this area and understands all of the complexities of the situation. So that's all I have in terms of presentation, but I am very happy to answer questions. I'm going to kind of exit out of this just in case.
There are two in the chat. So the first one is, if a spouse is working with legal aid, can an individual with a dementia diagnosis sign a POA when they are having a lucid moment as well?
Okay, so we're kind of going into the POA realm, and yes, powers of attorney also are subject to figuring out whether or not the person has capacity on that day. That's going to be the attorney's call to make. But that person needs to not just sign a power of attorney, but also needs to establish an attorney-client relationship with us. It's pretty easy to do, but you know, a lot of times in working with the OFA staff, they're working with a whole family, and as lawyers, we have an obligation to, as I said, establish an attorney-client relationship with each individual client. And sometimes that's not possible. And sometimes it is. We strive very, very diligently to make sure that that person's individual wishes are being ascertained, and to the extent that we can do so, being fulfilled. And that frequently means telling everybody else who may have come along for the ride, y'all need to wait outside while we talk to this person and see whether or not we can establish that attorney-client relationship, and whether or not they have capacity on that day or a subsequent day to sign the documents that they've articulated to us in a sufficient fashion that we believe that that's their wish to sign. So it's a little bit of a complicated factor, and you know, the law requires these things to try to protect people against bad actors. Most of the time, I don't believe that the family members who are working with OFA and who may have accompanied these folks to office appointments at legal aid, I don't believe they're bad actors. But we still have our rules to follow, and we cannot put someone's desires or necessities or convenience ahead of the client wishes and their capacity. It's a complicated question, but the short answer is yes, but, which is almost always an attorney answer.
Okay, second one. Can two people living together in a spousal relationship but not married be considered as the first in line of heirs under the law without a will in place?
No. You know, we live in an ever-evolving world, and at some point this may change. But in New York State, in order to be considered an heir, you must fit definitionally under the statute. And spouse means that you have been married in the way that the law defines marriage. I would have to look to see if a civil union qualified. My guess is that it probably does, but I've not actually had the question come up. But that requires a document. So if people have been living together, we call it cohabitating in the law, but they are not legally married, then they are not heirs. So there must be a will. So if you have, you know, Bill and James who have been living together for years, they never bothered to get married when the law changed to allow same-sex marriage. But for all intents and purposes, you know, they're a married couple, the way that we kind of think about that. The law draws a very distinct line between people who are married under the law of New York and people who are not. New York does not have common law marriage either, so that's not a way to get around it. And so if Bill and James want to make sure that when the first of them passes away, the other inherits everything, they need to either get married and be spouses, or they each need to have a will which specifies that that is what they want. It's a very important question. Thanks for whoever answered that. I asked that one.
Are there any other questions out there?
I thought I saw a little comment that popped up, but it went away.
Oh, there's one that says no questions for me. Thank you. Are there any other questions? Wow, we got a quiet group today.
We do. See the one above about, oh, I see the one above about gifts. There was a question about
Here we
gifts.
go. To confirm, gifts given prior to family members prior to death are not taxable, like silver, motorcycle, or camper?
Okay, so we're going to get into a tax question here. Generally speaking, you know, tax law is a very complicated area of the law, and I'm going to give you not an answer here. I went to law school with a young woman who her next step was to go and get essentially a graduate degree in tax law, and I said to her, I'm glad there are people like you who want to do this because relying on me would be a bad idea. There are different kinds of taxes, as we all know, because we pay lots of them. In this realm, we're running into things like state tax. We're running into things like gift tax. Gift taxes, you know, can apply to the person who receives the gift. It can apply to the person who gives the gift, and those sorts of things. So this is not an area about which I feel comfortable even doing instruction, except to say, sometimes yes, sometimes no. If a person has an issue, a question about this, they certainly can get a referral through legal aid. There are other folks who have dabbled in this area much more than I have and are much more qualified. But even then, if it's a complicated question, we may refer that out, you know, or refer that person to speak to a tax attorney.
Any other questions? You can unmute yourself and ask them, or you can type them in the chat box.
You never get it from me, now you're getting a call.
All right, it doesn't look like there's any other questions, so thanks for coming, everyone. Thank you, Alice, for presenting today,
Thank you.
and we will see you all next week.